Good afternoon, class and professor. My name is Michael Grieb, and today I'd like to talk to you about e-discovery. So today we'll go over what exactly e-discovery is, who carries out e-discovery processes, and then finally we can kind of apply what we learned to a particular case. So without further ado, let's get into it. So the first thing to know is kind of the discovery process. So the discovery process is obtaining any information that is related to a legal case. Traditionally, this would include papers, filing papers, work documents, personal letters, etc. So when we're specifically talking about e-discovery, we are specifically talking about obtaining electronic information that relates to a legal case. So in this case, electronic information can be stored on computers, on thumb drives. More commonly today, it can be stored on, or in the cloud rather. And finally, this electronic information relating to a case can be stored on cellular devices, via text, email, etc. So now that we've kind of learned that e-discovery is obtaining electronic information that regards to a legal case, we can now look at who carries out these e-discovery processes. So this is typically the job of a third party. These are called industrial security firms. So an industrial security firm would be hired by a company to kind of investigate, to obtain all of that electronically stored information in this case, and deliver it in report form back to the employer, who would then take that report into a legal case. So now that we know that e-discovery is obtaining information from electronically stored devices, and that industrial security firms are kind of the third-party source that employers rely on to carry out the e-discovery process, let's kind of apply that into a case. So in this case, we will be talking about Engineering Incorporated, or EI. So EI is currently bidding on a contract for a government project that's worth around $30 million. So in particular, Engineering Incorporated was kind of hesitant at first because in a previous project, a competing company won the bid, but the competing company's ideas for the project were very similar to Engineering Incorporated. And this kind of raised some suspicions with the CEO because somehow the information from his company was leaking out to a competitor's company, stealing his projects in a way. So the employer kind of took initiative into an investigation. So here we see a layout of the complex at Engineering Incorporated, and the employer had previously had investigating security measures in place. So in particular, we can see the central computer system had all the relevant ideas to the engineering company, all the important project plans, the project ideas, etc. So guarding this central computer system, we see that the employer had a security camera facing the only entrance of the building. So this was digitally recording, sending it to a computer system that could later be reviewed by the employer. Now the employer also had a keycard check-in, so an employee would have to swipe in order to gain access to the building, and every time an employee swiped in, that information was logged electronically to a computer system that told the employer when and who was entering the building at what times. So with these two forms of security measures, the employer was able to kind of narrow it down to one suspect. This employee rather, was habitually in the complex at irregular times when nobody was around. So with the employer's suspicion and now a suspect employee, the employer then calls an industrial security firm. So the industrial security firm started making its own security measures within Engineering Incorporated. So the first one was the industrial security firm installed a camera facing the central computer to catch the suspicious activity in the act. The ISF also implemented a employee login on the central computer system, indicating who was on the computer and at what times and what files they were accessing. ISF also ran a background check on the suspect. And finally, ISF put a GPS tracking device on the employee's company-owned vehicle. So at this point, ISF is holding a personal investigation against the suspected employee. So with the GPS, ISF was able to track the employee going to a local cafe. Now, the employee was not aware that ISF was right on their tail, and within that local cafe, the suspect was seen and filmed handing over a red flash drive to a suspected representative from a competing company. So after ISF had witnessed and recorded the suspect handing over the red flash drive to the other company's representative, ISF then tracked the company vehicle going to a competing company's building. Again, ISF followed them, and after a few hours, the employee had left that building. So ISF now has a competing company's building location, etc., and ISF had undergone their own investigating methods at the competing company. So this included dumpster diving. So while at the company's building site, ISF went through the dumpsters and they found a check invoice with the suspected employee's name on it written for $2,500. This kind of was the last piece of the puzzle, if you will. So ISF was able to gather all of that information and put it into a report form. And the next step would then to hand that report over to Engineering Incorporated, where Engineering Incorporated could then bring this case to trial for theft of trade secrets.
Okay, let me just stop you right there.
Yeah.
So you've got a situation where you have the engineering firm, they've got an employee who's stealing data of trade secrets from the engineering firm, correct?
Correct.
And then what they do is they're trying to figure out, well, why is that employee stealing the information? So they use legal methods through an industrial security firm that does this, that's their specialty, to figure out exactly who the other firm is and what in fact is being stolen, correct?
Correct.
All right. So at this point, if they terminate the employee, is the industrial security firm out of it?
So the industrial security firm is out of it. After the industrial security firm creates that report, it is all up to the employer to carry out that legal case against the employee.
Okay. Now, let's say that the firm sues, the employee sues the engineering firm.
Okay.
Obviously, the employee can ask through e-discovery, through the courts, they can ask for information from the engineering firm.
Correct.
All of their data that is relevant to the case.
Correct.
Can they ask the industrial security firm for information?
I do not believe so, because at that point, again, the industrial security firm is strictly for the investigating work, and then after all that investigating and that evidence collecting has taken place, all that evidence is now Engineering Incorporated's responsibility.
Okay, but the thing is, you're not correct there because of the fact that typically what the courts want is they want the best information.
Okay.
So they would want who took the pictures,
Sure.
who did all of this activity involving the data. So the industrial security firm could be pulled in too.
Would still be, okay.
Right. So then you've got two companies. You've got the industrial security firm and you have the engineering firm with a bad employee, in which what did they have to do to make it as easy as possible for them to hand over information to the employee that's suing them?
That is, you're talking about the
e-discovery. Like, what would you do in the video? They showed the biggest problem you have is you have all this data by both the industrial security firm and by the engineering firm. That's going to cost them a lot of money unless they do what?
So one of the biggest issues is a company really has to make sure that they have all their data and information, specifically in this case electronically, that all that information needs to be organized to kind of be able to prevent future costs of, again, like you were saying, having somebody come in and organizing it for them.
Okay, so that's a data retention policy, correct?
Yes.
All right, and the data retention policy is saying, hey, if you have data that you don't need, get rid of it.
Right.
If you have data that you do need, it should go in specific places so that it's easy to find it, right? Because if you think of law firms that go through prior to litigation and they're looking at all of this ESI, and you're talking about $500-$600 an hour, the cheapest, it's going to cost a lot of money, isn't it?
Sure, yeah.
All right, so let me just go through a few terms with you, as far as what is ESI specifically?
So ESI is the information, from my knowledge, is specifically the electronic information that is related to the case.
So it's data, isn't it?
Yes.
And you get the data from all of this technology.
Yes,
correct. Okay. Then the next thing is hold.
So hold is when a company first suspects that something might be going on. Holding is taking that, in this case, again, electronically stored information, taking that electronically stored information and making sure that it cannot be tampered with in any way, putting it in a safe location to be further reviewed later on during the legal case.
Okay, so I'm going to ask Pradeep if you can put these terms up for us. We have one that's, I'm sorry, perhaps you can find
yes.
So the first one we have is ESI. We got the data retention policy, very good that you're putting up. And then the next one is ESI that we just talked about. And then if you can put the hold up as well.
Yep.
So anytime that you have a situation where you think your data might be needed or necessary in litigation or arbitration, you should put a hold on that which you think is relevant information.
Right.
What about spoliation? What is spoliation?
So spoliation is the act of changing that electronic information prior to it going to a legal case. So in other words, tampering with the evidence, kind of the equivalent to, or at least in the electronic world.
Okay, so it's tampering with the evidence, which is against the law, isn't it?
Correct.
All right, good. Then the next one that we wanted to talk about was a clawback agreement. What is a clawback agreement? So
a clawback agreement is when a company asks another company for any relating information for a particular legal case. If one of the companies hands over a irrelevant document, that company has every right to take the rights away from the other company from having that information. So in other words, if you give another person information that's not relevant, you're able to take back that information.
So it's a mistake,
yes,
right?
Yes,
so you've
absolutely.
given information that has nothing to do with the case. It's just that there's so much data that you say, hey, wait a minute, we gave you this information. Right. Or if the other side sees that you've given them improper information, they have the duty
to hand it back.
Very good.
Yes.
Very good. Okay, and then are there any other terms that we need to go through?
I think that is all.
Okay.
I just kind of wanted to conclude with some. So in particular, with this case, the e-discovery parts would be accessing the databases for the cameras within the complex, accessing and obtaining the computer login logs, the key card access to the building that was stored in a computer system, and more oftenly overlooked is the GPS tracking, which is also important to keep in mind that is electronic information that is relevant to a case to see where somebody's at and kind of what they are doing. And then a few last points is, again, e-discovery is specifically the process of obtaining electronically stored information for a legal case. Again, like we were talking about earlier, the more time a business spends on organizing their data electronically, the less money they'll likely pay down the road if an issue were to occur, just because a firm doesn't have to go in and sort through it all. And finally, e-discovery is becoming more and more of an issue just because of advancements in technology, and everybody is switching over to kind of the electronic-based system. So, yeah, I think that's all I have. Thank you for listening. And
nice job. Let me ask you this. I just want to ask you a couple more questions. Are those state laws or federal laws, or are they court rules that determine e-discovery and how you have to abide by e-discovery?
So from my understanding, it is federal and state that make the laws for the court rules. Is that
okay? So the court they adopt those rules and they pass them, but they have the impact of law. So it's not the legislature that does it; it's the courts themselves.
Okay, so the courts decide.
And then if it's an arbitrator, many times the arbitrator will adopt either the state or federal rules of evidence. But if you don't comply with the rules of e-discovery, you do so at your peril. I mean, you can be fined and you can be put in jail for that. So you did a real nice job. Thank you very much.
Thank you very much.
Thank you.